What is law? Welcome to the course. English legal system is all about understanding the basic vocabulary of law and the institutions that are involved in making the law and enforcing it. What makes understanding English legal system interesting is the fact that it not only helps you in understanding the fundamental concepts of law, but it will also help you understand other substantive modules of law like contract law, tort, and criminal law. The course also acts as a great resource to learn how to read cases and statutes. Let's start from the basics. So what is law? Even before we ask this question, we need to know why is this an important question? What are your thoughts on this? Why do you think we need to even consider this question? The first answer you might come up with is that it's natural to wonder about law if you're going to study law, or if you have ever come across anything that's legal in your life. By the way, that happens all the time. Like the last time you bought something from a shop or online, you may have benefited from the consumer protection laws or have signed a contract. Another reason we might be interested is because law is all about understanding complex phenomena, and to understand what law is can provide us with a good start. This will not only make us a good lawyer, but also a good law-abiding citizen. Let's look at an example. You are making a video for your YouTube channel, and your inner artist wants to add some dramatic music in the background. So you start looking for music on the internet. You come across a library of music on a website, and the website allows the use of music under a Creative Commons license. As you try to understand what is a Creative Commons license, you are actually trying to find out what is law. So what is law? Is law a set of rules? Or is it based on morality? Or can it be found in the work of lawyers and judges? Is it what Parliament legislates? Or maybe it's a tool of oppression by the elite to suppress the poor? The definition of law can have many interpretations, just like any other complex phenomenon. Let's compare it with currency. We all know how to use money, but we might need to do some serious research in order to define currency. Again, we will come across many different ways of looking at the currency. Currency can be thought of as a tool to facilitate economic activity, or a representation of one's labor, or maybe a tool used by the superpowers to keep control of the world. You can see these all are very diverse and abstract approaches in answering the question. So we have to find a better, more concrete approach to answer the question, what is law? Here is a list of different approaches that we will take to understand this complex question. We will look at law through its functions, as a set of rules, as a legal system, through its constitutional arrangement, and finally through its sources. Let's first look at the functions of law. We are starting here because this is the most intuitive way of looking at law. As Aristotle puts it, law is order and good law is good order. So let's look at the function of law in our personal life and in our society. The law performs many functions: to keep order in the society, to protect human rights and civil liberties, to preserve our democratic way of life and enable the political system, to facilitate the economic activity, which includes protection to businesses and consumers, to regulate our relationships like marriage, to preserve morals and norms, and the greatest virtue of all, to preserve world peace. Food for thought. What happens when two functions of law come in conflict with each other? For example, the function to keep order and the right to demonstrate. How can the government justify its action to restrict demonstrators who are expressing their dissatisfaction for the government through protests? Another challenge is globalization. How can law preserve morals and norms with the birth of plural societies? Enough about the functions. Let's look at law as a set of rules and regulations. We are always surrounded by all of these different kinds of rules in the society. For example, Don't cross the road without zebra crossing, don't cut a line, don't talk in the library, or don't drive over the speed limit. As you can see, not all of them are laws. What makes some of them law is the fact that they were enacted by the Parliament as statutes. So why do we let Parliament make laws for us, or in legal terms, legislate for us? Because we want to make sure everyone is driving at a reasonable speed, and if someone violates that rule, they should be punished in the form of fines or imprisonment. This way we can ensure the safety of everyone who is on the road. In a post-EU world, it has become much more important to communicate these rules to the immigrant communities so they can easily adjust to the rules in the host country. Another way of looking at law is through its constitutional arrangement. This basically means that there are different doctrines or principles that can be used to define a legal system. These principles are a big part of this course, so they will be discussed in detail in later lectures. But since we have taken upon the impossible task of defining law, we will be looking at them here briefly. The first principle is parliamentary supremacy, which means that in theory, the Parliament is the supreme lawmaking authority in the UK. The second principle is the rule of law, which means that no one is above the law. A nation should be governed by law, not arbitrary decisions made by government officials. The third principle is separation of power. The power of state is divided between different institutions, and no one institution is extremely powerful and free from accountability. The power is divided between the legislative, executive, and judicial branches of the state. The fourth is the prerogative powers of the Crown. These powers are unique to UK due to its continuous history from the last 1000 years. These powers are held by the executive branch in countries like the US and France. In these countries, the revolutions and the discontinuity gave way to the shift of the prerogative powers to the executive branch and away from the royalty.